more to life as you get to these various rules in your evidence course. But some of it will be a little bit intuitive regarding the foundational requirements, even in the more formalized rule of evidence that it may be referencing. So first of all, why are exhibits important? What is the purpose of using exhibits at trial? There are a couple of benefits and essential benefits that mandate your use of exhibits at trial. You're not going to be in a good position to capture the juror's interest, to hold that interest, to assure their retention of the testimonial evidence that you're presenting without the sensory aids of exhibits. So one thing that exhibits do is that they help to explain and clarify the testimony. We have an intuitive notion that complex matters are more easily digestible with the assistance of a photograph or a chart or a model or some other explanatory device that reinforces the words that are coming through the witness's testimony on examination. So, in a very simple example is trying to explain that accident scene. In front of the restaurant, the 3 lanes of traffic, one used for valet, the direction in which the cars are going, and the ultimate collision. Whether you're explaining it from the plaintiff or defendant standpoint, it's much more easily understood if it's supplemented with a diagram of that particular street scene, right? It just reinforces it. So it helps explain and clarify the testimony. Another thing it does is that it reinforces the testimony and it enhances the juror's retention. So not only does it clarify their understanding of the events that are being described, but it actually helps them to remember it, and to remember it as you are describing it through the testimony. That's why the concurrent admission of the exhibits to support the testimony is important. If you try to wait till closing argument to do that, it's not going to have the same impact as if you were introducing them to the concept with the exhibits at the time that concept was being first presented to them. And then in the closing argument, you can refer back to that. You can even use those same exhibits, and it'll be instantaneously remembered by the jury. And more important, its probative connection to the evidence. If you're using the exhibits to supplement the testimony as you go. So it reinforces and enhances the juror's retention. Another thing it does, exhibits tend to heighten and maintain jurors' interest. There is nothing like a good demonstrative aid to heighten a juror's interest in what is being said, right? No words could equal O.J. Simpson trying on the glove, right? You could talk about it not being a glove that would fit his hands. You could talk about the lack of connection between him and the glove, but having him try on that bloody glove, which was allegedly used by his ex-wife's murderer, and seeing the glove not fit his hands, there is no substitute for that, right? So that simple demonstration, and then showing that glove and having the jurors, examine the glove, just reinforces that imagery and certainly catches their attention, right? It's probably one of the most dramatic moments in modern trial history. And then, of course, at the closing, all Simpson's lawyers had to do was to reiterate the importance of that glove and the imagery of him trying to put on the glove and it not fitting. And of course, the famous words from Johnny Cochran, if it doesn't fit, you must acquit, right? So All of that came together with the simple act of having O.J. Simpson try on the glove. Of course, it's perhaps one of the biggest faux pas in litigation history that it was the prosecution that asked him to try on the glove, which is another story, another aspect of litigation, and that is you never turn over a demonstration to the other side. But my point is the impact of having O.J. Simpson try on that glove visually. Okay, a final benefit is that it satisfies jurors' expectations. You know, jurors, modern jurors in particular, they're sophisticated consumers in terms of how they get their information, and you have to, adjust to that in terms of whatever technological tools you may have at your disposal to satisfy what they expect to hear and see in the way of exhibits. And it also satisfies the juror's need for visual stimulation, right? Interjecting that visual stimulation helps to maintain the juror's interest and fulfill their expectations. In a sense, they do expect to be entertained to a certain extent. And that is to say that it is monotonous to just listen to witness after witness, especially when that witness's testimony is oftentimes disrupted with objections and court recesses and other events that disrupt the flow of information. So, these visual aids that stimulate jurors' interest is important for keeping them on task. So let's talk about the different types of exhibits in demonstrative aids. There are basically three types of exhibits. There's real evidence, documentary evidence, and demonstrative evidence. Real evidence is sometimes referred to as original or physical evidence, usually a tangible item like the gun from a murder scene, the torn seat belt from the plaintiff's automobile, cocaine that's found on the possession of the defendant. So physical, tangible items. The next category is documentary evidence, which, as the name suggests, refers to writings or recordings that are being offered to prove their content. Now, documents have to be introduced into evidence to prove that their contents are meet the best evidence requirement under Federal Rule of Evidence 1002. And we'll talk a little bit about some of the more common forms of documentary evidence, business records in particular, and what the foundational requirements are for that. And then the third category would be demonstrative evidence, and that generally refers to tangible evidence that explains a fact that the advocate is trying to prove. So it's distinguished from real or documentary evidence in that it doesn't have any independent probative value. It's played no role in the actual dispute between the parties, but rather it's used in conjunction with the witness's testimony to clarify that witness's testimony, to explain it, to highlight it, to emphasize certain aspects of it. And demonstrative evidence would consist of things such as drawings or maps or charts, diagrams, models, photographs, lists, etc. But the scope of demonstrative evidence is limited only by the creativity of the advocate. But generally, that's what demonstrative evidence entails. So let's talk about the foundation that you have to lay for any exhibit that you are going to seek to introduce into evidence. Every piece of evidence that is offered during the trial has to have a proper foundation. and you, the attorney, are responsible for laying that foundation and having the admissibility of that evidence approved by the judge before you can introduce it to the jury. So it's a critical step. It's not something that can be fudged. It can sometimes be fairly technical, depending upon the type of evidence in particular, and the federal rule that is tied to the admissibility of that evidence. And oftentimes you have to track as much as possible the language of the federal rule that is implicated in order to lay the proper foundation. It's not fun when you get an objection from the other side, objecting to its admissibility because of a lack of a proper foundation, right? So, it's important that you go square around the corners in laying the proper foundation for the various types of exhibits as required under the federal rules. So you have to do that before you show the exhibit to the jury. The exhibits have to be relevant, reliable, and authentic. Right? And for all exhibits except those that are self-authenticating, and there's a host of self-authenticating exhibits that I think when you get to rules of evidence, there's a whole list of them, a lot of public records, for example. That's the most prominent example of self-authenticating exhibits. But for other than those self-authenticating exhibits, authentication is going to require foundational testimony from a witness. That's how you lay the foundation. So in the language of the federal rules, the party offering the exhibit has to show that the exhibit is what the proponent claims it to be. So in a word, that's establishing its authenticity. So that means that the party has to present sufficient information or proof that a reasonable juror could find the exhibit is what the party purports it to be. All right, so let's get into laying the foundation and actually introducing the exhibits. The first step is to actually describe the exhibit. Remember, the record has to reflect what is being done in the courtroom. So you can't just pick up a knife or a gun or a bloody glove and start, parading around the courtroom, asking the witness questions about the item, right? There's a sequence that you have to go through. And, this is perhaps a little more formal than you may need to do in every situation, but it's better to have a full, more formalized understanding of the steps so that, if you want to take some shortcuts and some liberties, you may, especially depending upon the judge or whatever, but you need to consider all of these things when you pull out an exhibit and start to lay the foundation, right? Now, as to when you're going to introduce an exhibit, by the way, it's going to be at that part of the testimony where it's logical to introduce it, right? If if it's a piece of tangible evidence, real evidence, it's going to be in that witness's testimony where they first talk about that thing, whether it's a helmet or a gun or a knife, right? And you want to get that real evidence introduced to reinforce what they're talking about? Well, that's a pretty good time when they mention it, right? That's a good time to, okay, I'm going to start laying the foundation. Now, as to the steps, describe the exhibit. That's the very first step. You have to describe it with some particularity. It should be objective, it should be relatively neutral, and it should be designed just to make sure that the record is clear as to what you are doing. So, for example, Your Honor, may the record reflect I'm holding a knife that is approximately 12 inches long. Right? It has a fixed blade and a wooden handle. Okay, you've described the exhibit. So the next step up here is to mark the exhibit for identification. And you need to ask leave of court to approach the clerk to have the exhibit marked for identification. Now, obviously, that's not going to be necessary if the exhibits are pre-marked. And in many, many courts today, most of the exhibits are going to be pre-marked. And there are going to be stipulations as to the admissibility of a lot of these exhibits. So you may not have to do this for every exhibit. And if they're pre-marked, you can dispense with the formality of asking legal court to approach the clerk or whoever in that courtroom is responsible for marking the exhibit. The exhibit, and even if they are pre-marked, there inevitably will be exhibits that are not pre-marked, you know, that maybe came up at the last minute after, you know, the exchange of exhibits and the marking of exhibits was accomplished, and or for whatever other reason. So you're going to have to, you know how to do this step. Your Honor, may I approach the clerk to have Plaintiff's Exhibit 1 marked for identification? Yes, you may. I know it sounds overly formal, and if you don't have to do it, great, but you should know what to do if you have to have it marked on the spot. Some jurisdictions will use numbers to mark it, some will use letters, some will use numbers for one side or letters for the other. It doesn't matter what mechanism they use or what methodology they use. They will put some identification on that exhibit, and then you refer to that identification. If they're using a number system, and it's the first for the plaintiff, the first exhibit, plaintiff's 1 for identification, you will refer to the exhibit henceforth as Plaintiff's Exhibit 1 for identification as you are laying the foundation, and then after it's moved into evidence, you can dispense with for identification. But until it's accepted into evidence, you have to refer to it as exhibit whatever for identification. Okay, so the next step up here is to show the exhibit to opposing counsel. You have to play nice, you have to share your toys, right? That does a couple of things. First of all, it shows that you're being open and fair about the process. You're giving the other side the opportunity to examine it before moving into evidence. And it preempts any complaint by opposing counsel that they are somehow being unfairly deprived of the opportunity to see it before it's being offered into evidence. So it's best to get that out of the way before you cut to the chase and get to the heart of the foundation. So now, again, you got to be mindful of the record, so you may want to think about it. I know Professor Celino does a little bit less formal, and that's a good alternative. My personal preference is to indicate that, what is happening when we're showing the opposing counsel the exhibit. So let the record reflect that I'm showing opposing counsel Plaintiff's 1 for identification. Okay, but I know Professor Celino does a little more streamlined fashion, and a little less formalized. Okay, so you've played nice. You've shown it to opposing counsel. And the next step is to give the exhibit to the witness and lay the foundation. Okay, this is where the rubber meets the road. And lay that foundation, and lay the foundation depending upon whatever the federal rules require for that particular type of exhibit. So the specific foundation is going to vary, and it's going to depend on the nature of the exhibit and the intended use of the exhibit. But the most common means of authentication of an exhibit is by personal knowledge of the authenticating witness. And that simply requires the witness to identify what it is, what the object is, and why they know it is what they said it was. Okay, well, that sounds a little awkward, but do you recognize it? How do you recognize it? Well, yeah, it's the letter that I wrote, or it's the helmet that I use when I ride my motorcycle, or whatever the basis of personal knowledge is that provides the requisite authentication for that exhibit. And many times the foundation can be laid with just 2 questions. I've just shown you Plaintiff's 1 for identification. Do you recognize it? Yes, I do. How do you recognize it? Really simply, those 2 questions oftentimes can lay the requisite foundation. Now, that's clearly not going to be applicable to the more complicated and technical types of foundations you have to lay for specific exhibits. Okay, so let's assume you've laid the foundation and you've withstood any potential objections from opposing counsel. It's time to move the exhibit into evidence. And so once you've laid an adequate foundation and the exhibit has been authenticated, you would basically ask the court permission to move the exhibit into evidence, or you actually move the exhibit into evidence. And it might sound something like, Your Honor, at this time, I move plaintiff's exhibit 1 for identification into evidence. Judge will then look to opposing counsel. Any objection? No, Your Honor. Assuming you've laid the proper foundation, you get that no objection, Your Honor, you're good to go. So plaintiff's exhibit 1 is admitted. Now, if opposing counsel believes you haven't laid an adequate foundation, which is another reason why you want to make sure you know your rules of evidence for that particular type of exhibit, opposing counsel needs to and will object before the exhibit is admitted into evidence. And if the judge sustains the objection, then you, as the proponent of that exhibit, you have some choices to make. You can resume your questioning of the witness, and then later on in the testimony try to get it in again. If you ultimately fail at getting into evidence that exhibit, and that exhibit is material to your case, you may have to make an offer of proof. But all of that can be avoided with proper authentication tied to the requirements under the rules of evidence. Now, you're not going to win every battle. They're just, some are going to be close calls, and you're going to lose some. And you have to be, prepared to alter your litigation strategy if that happens. Offer of proof, a proffer, maybe one, way to deal with it. Or you may just have to, live without it. But you will know what will be contested, and usually the basis for its, opposition from the other side. And you can also, do away with a lot of that with motions in limine. So, too many battles that you have to fight for the admissibility of exhibits, or you know that you got the foundation you need and you've done it properly, and so you're likely to withstand any opposition from opposing counsel. Now, the opponent, in addition to making an objection based on lack of foundation, they can also seek to voir dire the witness with respect to the foundation purportedly laid by the proponent of the exhibit. Now, that voir dire is not the same as voir dire that we talk about in selecting jurors. This voir dire is limited to the foundation of the exhibit. So the questions pertain only to that aspect of the case. So the opposing side can ask the judge to voir dire the witness to test the underlying foundation that was made by the plaintiff. So it might sound something like, Your Honor, I object, there's no foundation, and Plaintiff's Exhibit 1, is whatever it is. May I take the witness on voir dire? Yes, you may. And then the opposing counsel will proceed to ask questions about, well, did you write that memo at the time that the events in the memo were happening? Or did someone else edit that memo that you wrote? Or whatever you're testing in terms of the adequacy of the foundation. Or if it's a business record, was it kept contemporaneously? Was it kept by someone whose responsibility is to keep that record? Is that the normal way the business keeps the record? I'm just giving you examples of the voir dire that might test the sufficiency of the foundation. And if the opposing counsel is dissatisfied with the foundation, at the end of that voir dire, he'll just renew his foundation objection, for whatever basis he believes is, a sufficient basis to challenge him, given the answers he got from voir dire. So, assuming you get through all of that, the very last thing to do is publish the exhibit to the jury, right? This is the payoff, right? Going through all of that, you don't forget to publish it to the jury. So, the particular method of publication will just depend on what it is you have. You know, if it's documents, there are a variety of ways you could do that. You can have copies for the jurors to physically hold. You could project them up on the screen. You know, if it's a piece of real evidence, you know, obviously you want them to hold it, to touch it, to feel it. Those tactile and sensory impressions are important. So, you know, it just depends on what it is and what's the most efficient way to have the jury actually see what it is that you've been trying to get into evidence. You know, to get the benefit of all of those things we talked about at the beginning as to why you want to introduce the exhibit to begin with, right? Now, you have to give some thought with respect to the publication. For example, if you're going to have copies for every juror to read, you don't want that act of reading to interfere with your continued direct examination of the witness. They're reading whatever you've given them, and you know, they're not listening to the testimony. So you have to think logistically, what is the most efficient, effective way to get this information to the jury, so that you don't disrupt or distract attention from the examination itself. You also, when you publish it, you know, especially if it's being projected, you have to make sure that the sign lights are good for every juror, right? And it's plainly visible and accessible to every juror. That's it for laying the foundation. I don't think I have any more slides. So let me just talk about foundations for specific types of exhibits, starting with real evidence. As we stated earlier, real evidence is tangible pieces of evidence involved in the circumstances that gave rise to the claims or defenses in the case. In your case, I'm just trying to think through the case file. One obvious piece of real evidence, for example, would be Jackie's motorcycle helmet. And allegedly, Jackie's helmet was not fastened with a chin strap, and thus, you know, it came off of his head when he collided with Mr. Parker's car. So that's an example of real evidence in this case. Oftentimes, the foundation for real evidence, especially something like that, can be laid through one witness, right? Jackie, I'm showing you Plaintiff's Exhibit 1 for identification. Do you recognize it? Yes, it's my motorcycle helmet. How do you recognize it as your motorcycle helmet? Well, you know, that's the same make, model, color, and it has distinctive markings on it, such as the skid marks the last time I went flying. Okay.
And Blaine, I don't mean to interrupt,
Yeah,
but
please interrupt.
right, but we're going to ask you all in your groups on Monday to introduce the helmet, and you have to lay a foundation under 901 that the helmet is what you purport it to be. And you don't just purport that it's a helmet. You purport it was the helmet that Jackie was wearing at the time of the accident. So you need to figure out how to lay that foundation. It's not hard, as Blaine was just saying. But that's, for example, a piece of real evidence that we're going to ask you all to introduce on Monday.
Yeah. Yeah.
Isn't it not real evidence? Isn't it just like a picture in the case file?
Yeah.
It is, because you can't fit a helmet into the book.
Yeah.
But we're going to pretend that we have a real
Okay,
helmet.
I got you.
Yeah, I've got a real helmet that I've used when I have a small class, but I don't have 5 real helmets.
Right, we just pretend that we have a real helmet.
Yeah, it takes a little bit of imagination. That's
Very little bit.
Yeah, but it's, you know,
Right.
to have empty hands.
Somebody can bring a tinfoil helmet if they want.
That's a good idea. So most of the time, or I shouldn't say most of the time, it really just depends. One witness will be sufficient to, to authenticate that real evidence, but sometimes, and I don't know that there are any instances in this case, but I just want to alert you to the fact that sometimes the authentication of real evidence requires the testimony of more than one witness, especially if you have to, for example, establish a chain of custody. A chain of custody is going to be necessary if the item is not uniquely distinguishable in some way, right? All cocaine looks alike, right? All counterfeit money bears a resemblance to real currency. So you may have to, and I won't go into the specifics of this, but just wanted to alert you to the occasional need to use multiple witnesses. You may need to call the chemist that tested the cocaine. You may need to call the custodian of the evidence locker to say, when he got the cocaine, what he did with it, what happened to that cocaine from every point in custody till the time it made its way to court. You get the idea. So, that's essentially all I wanted to say about laying the foundation. But you're going to have a chance to do that, as Professor Cialino said, with respect to the helmet. So, you should start thinking about that. By the way, in the Loubet book, you probably have more detailed information. I'm just kind of like giving you the high points of some of these things. But I do believe in the book, they go through examples of just about every kind of evidentiary scenario that you might expect to encounter. Now, let's talk about the foundation for documentary evidence, which consists largely of writings that a party is seeking to have admitted during trial. That kind of exhibit can be authenticated by any of a number of means, depending upon the circumstances and the nature of the document. That's governed largely by Article 901, which lays out a variety of scenarios for authenticating documentary evidence. It could be, for example, on personal observation of the document being prepared or signed, or a lay witness's opinion on the handwriting contained in the document, or an expert's opinion on the handwriting, or distinctive contents of that handwriting. I would just refer you to Article 901 to see the various ways in which documentary evidence can be admitted. But I do want to specify with some particularity one of the more common types of documentary evidence, which just about every case will have. I mean, it's hard to envision a case that does not have business records involved in a case as a potential exhibit. So, with respect to authenticating business records, when we talk about business records, you think of things like medical records, accidents reports, business memoranda, financial data, employee evaluations. I mean, it can go on and on and on. But the proponent of that record has to establish that the records are both authentic and that they fall within the hearsay exception for business records or some other provision. So business records can be admitted through an affidavit or a declaration by the custodian of those records, establishing that the records are those of the company and that they fit within the business records hearsay exception, which is outlined in Article 902, Subdivision 11. Alternatively, business records can be authenticated by a witness who is familiar with how those records were created and can competently testify about the process. So a couple of essential features under the federal business records exception, under Rule 803, Subdivision 6, the proponent has to establish a few key things. The first is that the document was made at or near the time of the events that it's describing. Okay. The second is that it was made by somebody with personal knowledge or based upon information from someone with personal knowledge who had a duty, a business duty, as an employee to report or record the information. Thirdly, that it was kept in the regular course of regularly conducted business activity. And then finally, that it was the regular practice of that business activity to make that record. So each of those requirements have to be met. And as I alluded to earlier, this is one of those instances where you, as the proponent of that business record, to the extent possible, should try to track the precise language of the rule in laying the foundation for that business record.
Yeah, and again, I hate to interrupt again, Blaine, but we're gonna ask you all to do this on Monday with a business record from the file. You're gonna have to, it's really almost like a kind of a talismanic incantation as you go through, like you're almost doing casting a spell. You go through each one of those foundations that you have to establish with the witness. And the witness is both, basically just gonna be kind of saying, yeah, yeah, yeah. And you go through all that, and then you offer it as as a business record, and you satisfy the 901 authentication requirement and the 803 hearsay exception.
Yeah, it does. These things at first blush seem overly formalized, and it's like, my God, you're asking me to remember all this stuff too? I gotta remember all the facts in the case, I gotta pay attention to what the witness is saying, I gotta use, effective direct examination technique, I gotta know the darn law, I gotta deal with this judge who's on my you-know-what, opposing counsel is a jack in the box, objecting to everything, now you're telling me I gotta go through all this formal stuff?
And that's annoying, it's true. But, I teach evidence in this class, and when at a hearing, if I've got to get a business record in that the other side's being annoying about and objecting to, I have in my outline for the witness, spell it out, because I don't trust myself to remember all those five elements. And I know it sounds ridiculous that I'm gonna go to my checklist, the evidence teacher, but I do, because you just wanna track the rules. So when you all do this on Monday and you get to bring up notes, just put the things you need to prove, the foundational elements for this.
That's one instance where notes is not
Exactly.
only helpful, but probably a wise thing.
Exactly.
So, made at the time, personal knowledge, regular course of business.
And just
regular
ask them
practice.
as leading questions and get the witness just to go, yep, yeah, oh, yeah, yeah, yeah.
Yeah, and you're permitted, that's one of the few exceptions on the record where you're permitted to lead. So, I know it's a lot to juggle, but that's why trying cases is right up there with brain surgery in terms of the challenges.
Right, so that's the second thing that you all are gonna have to do on Monday, is introduce a business record.
I'm trying to think, do we have a business record in the case file? Which one? I know we,
Spencer Flanagan,
oh,
Chief
yeah,
Financial Officer.
yeah, well, that's a good example.
Yeah, so figure out what witness you'll call for that and go through with a bunch of leading questions to get it in. It won't be hard, but you just have to go through the incantation. And we're gonna make you, and this is gonna be clunky, when you stand up, go give the exhibit to your opponent, give a copy to the judge, give a copy to the witness, go back to the podium. But it's just something that you just have to go through the motions.
Yeah, but it really becomes intuitive. I mean, just think about the logical sequence of what you would have to do. Your Honor, I'm holding this. Permission to have the clerk identify this as plaintiff's next in order, right? Go with the clerk, get it done. Play nice, show your toys, right? Let the record reflect I'm showing plaintiff's one for identification of opposing counsel. Your Honor, may I approach the witness, right? After, of course, he's had a chance to look at it. Okay, Mr. Witness, I'm showing you plaintiff's one for identification. Do you recognize this? How do you recognize it? So that becomes really one fluid sequence of movements. Don't think about it. Just think about the intuitively what you would have to do to make sure that that item is properly accounted for in the record, and who you need to approach in what sequence, and asking permission to do so. First few times you do it though, you're gonna overthink it and you're gonna feel, okay, where am I? I'm in the third step or the fourth step, or what am I doing? And at the end of it all, you might forget to show it to the jury. Because you may be so exhausted mentally and so thankful that you got through the process that you forget why you went through the process, which is to publish it to the jury. Okay. All right, the last thing I want to talk about very briefly, demonstrative evidence and visual aids. That's the third category of evidence. That too requires authentication.
And you all will be doing this on Monday too.
Oh,
Yeah, like with a map or.
yeah, that's true. We have a diagram.
Yeah, diagram, map, right.
Yeah. So, because demonstrative evidence only illustrates the actual thing that has significance in the case, it might be a diagram of the intersection. The required foundation requires more than a showing of just personal knowledge. The proponent has to also establish that the demonstrative evidence, and these are magical, talismanic words, sorry to hit you with that it fairly and accurately depicts the thing as it was. So if it's a photograph, if it's a fair and accurate depiction of, Jackie playing tennis. It's not playing tennis in this fact pattern, but you get the idea. Or if it's a drawing of the scene, does it, is it a fair and accurate depiction of the intersection at, Claiborne and Nashville, whatever it is that diagram is purporting to replicate. So, as Professor Cellino mentioned, you're going to have to, or be prepared to, do any one of those, right? Either a piece of real evidence.
Well, I think, I think if we could do 4 different things, which would be a photograph, a demonstrative exhibit like a map, a real exhibit, the helmet, and then a business record. So that's 4 different things. Come prepared to do all 4 things. Again, this will probably be the easiest preparation week of the whole semester. But just, figure out how to get those 4 things in from reading Loubet, listening to Professor Lassen's lecture, and then that's what we're going to do. Those four things. Now, it may be that you don't get called on to do all 4 things because we don't have time for you to perform 4 times. Although these performances are going to be very short, it really shouldn't take more than a minute to authenticate a piece of evidence. Minute and a half at the outset. So you may wind up doing all 4. But if you come prepared to do those 4 things, that's what we're looking for.
So in terms of witnesses, the witnesses are going to be really...
Well, the witnesses really should just be, kind
Say yes.
of trained seals.
Yeah.
They should just go, yes, 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 and then when they're done, you flip them the fish.
Yeah. Don't make it difficult for a
Yeah.
person trying
I
to...
mean, 'cause since you can lead on this, the witness doesn't really need to know anything other than how to say the word.
So you're just a warm body if you're asked to serve as the witness. So we'll have to tell the adjuncts to vary it up.
Right.
Now, you know the file, you know which side you're on, be prepared to do a form of each of those categories of evidence. Okay? Yeah.
So what are the 4 pieces of that? There's the map, the business.
The map, which is demonstrative evidence.
Right.
A photograph, right?
Do we have a photograph in here?
Map, photograph, business record, and helmet.
Yeah, helmet should take 30 seconds.
Yeah, all of them should be quick. The longest one's gonna be the business record, but everything else fairly quick.
Look at 803.6.
But not only think about substantively what foundation you want to lay, but also think about those mechanical movements around the courtroom that will one day be second nature, but they will not be second nature on Monday. All right.